He was the eighth Chief Justice from 1888 to 1910, who had mixed reputations. He was born in Augusta, the capital of Maine, on February 11, 1833. His family tradition biased him toward legal career. His father, Frederick August Fuller, was an attorney in Augusta. 3 months after Fuller's birth, his mom, Catherine Weston, filed suit for divorce, which led to Fuller spend his formative years under the influence of his grandfather, George Weston. His maternal grandfather, Nathan Weston, served as Chief Justice from 1833 to 1841. His paternal grandfather, Henry Weld Fuller, was a probate judge in Kennebec County. In addition, he has an uncle, George Melville Weston, who was a lawyer in Bangor. He entered Bowdoin College at the age of 16 in September 1849. Fuller was an active debater and pursued his passion for writing poetry. Fuller helped from a granite club which helped to support Pierce's campaign for the presidency. He graduated from Bowdoin in September 1853. He studied law in Bangor office of his uncle, George Melville Weston. He entered Harvard Law School in fall 1854 and attended lecture for 6 months there. His principal occupation was an associate editor of Augusta Age, the leading Democratic Party newspaper in Maine. He elected to Augusta Common Council in March 1856. He also promptly appointed both president of council and Augusta city solicitor. Fuller accepted a salaried post with Samuel K. Doe, another native of Maine, who was a successful attorney. He was elected to Illinois House of Representatives from a usually Republican Chicago district. Fuller represented the Union National Bank, frequently appeared on behalf of other Illinois banks, and also represented prominent business figures. He served as attorney for the Chicago Gaslight and Coke Company in a contract dispute with another gas company. He became the attorney of South Park Commissions in 1882 and tried many eminent domain cases. He also represented corporate interests and wealthy individuals. The sudden death of Chief Justice Morrison R. Waite on March 23, 1888, created an opportunity for Fuller's place in Chief Justice. President Cleveland, a Democrat, considered a large field of possible candidates, but finally decided to select a Chief Justice from outside the existing court membership. President Cleveland first approached Judge John Schofield, but received a decline. President Cleveland offered Fuller the chairman of Civil Service Commission, but refused by Fuller. Fuller refused another 2 presidential appointments, which are the post of Solicitor General and one of the 3 United States Pacific Railway Commissions. President Cleveland appointed the position of Chief Justice to Fuller despite he was the first appointee who had not previously held a federal office. The first landmark case is Field v. Clark. He said that Congress could not transfer legislative authority to anyone else. The second case was United States v. Easy Night Company. He proclaimed that the states retained power to move against manufacturing monopolies. The third case was Pollock v. Farmers Loan and Trust Company. He declared that the federal income tax law of 1894 is unconstitutional. After 22 years service in Supreme Court, Fuller died on July 4, 1910, in the age of 77. Here's some interesting facts about him. Fuller was a Democratic loyalist, but he won the respect from the Republicans. Fuller denounced Lincoln's steps to end slavery and Lincoln's policy, but despite his denouncement toward Lincoln, Fuller was appointed to a committee of 100 prominent Chicago citizens who escorted the president's remains to Springfield after the assassination of Lincoln. Fuller has 2 marriages, and both aimed him on his financial and professional status. After the death of his first wife, Celestia Renois, he rented out the property and received a sizable rental income. The second marriage was Mary Ellen, allowed him to get closer to his wife's father, William Corbell, who was a wealth banker and the president of Union National Bank. Fuller was one of the busiest attorneys in Chicago who tried approximately 2,500 cases during his career. The salary of the Chief Justice was $10,500 a year, which is much less than Fuller's former income. New York Times Company vs. United States. One of the press, New York Times Company published the classified Pentagon Papers, which was considered too harmful to national security by Nixon administration. Brought this to the court. The court held an exceptional Saturday session to hear the argument on June 26, 1971, and this case was decided on June 30, 1971. The government brought this. The case was originated in New York at District Court of Southern District of New York. Case began when New York Times published a classified document which is considered harmful to the government. The New York Times published a classified document, Pentagon Papers, on its newspaper. The government, Nixon administration, brought this to the court because of national security, which might endanger U.S. troops in Vietnam and damage U.S. credence. A federal judge issued a temporary restraining order against the New York Times. The case went to Supreme Court. However, the court found Nixon administration did not qualify the burden brought by the publication. This case went to the Supreme Court as a violation of the First Amendment. The government, Nixon administration, asked the federal judge to issue a temporary restraining order against the Times, so this case went to the Supreme Court. The decision was 6-3. The justice in majority concluded that the publication of the Pentagon Paper did not bring heavy burdens that is necessary to prevent publication protected by the First Amendment. Only when the government can prove that the publication will inevitably, directly, and immediately affect the government. Since this is an unprecedented court case that the majority court justice choose not to believe the government's assertion about the potential impact brought by the publication, this court case can be considered as an extraordinary victory for freedom of press. In addition, the end of this court case re-energized the national debate over the wisdom of speech, which protected by the First Amendment.